The content of this video is provided for information purposes only. It does not constitute legal advice.
Central Coast Community Legal Centre is a community-run organisation. Unlike legal aid, we don't represent our clients in court. Instead, we provide timely legal advice and education to help members of our community represent themselves. This video is primarily meant for people who are defending an AVO, but whether you're a person in need of protection or an AVO is being taken out against you, this information will help you get familiar with courtroom process and what to do on your first day in court. We'll explain how an AVO is put in place and what your options are. To start with, let's look at what an AVO actually is.
The first thing to know is what kind of apprehended violence order you want to apply for or has been brought against you. There are two types. The first is an apprehended domestic violence order, or AVO, which covers domestic relationships, including with your partner, children, parents, or other people you live with. The second type is an apprehended personal violence order, or APVO, which covers your relationship with neighbours, colleagues, and other people outside your home. An AVO is a court order. It is not a private agreement between the people involved.
Depending on who has issued your AVO, it will either be a temporary AVO or a final AVO. Temporary AVOs, known as provisional or interim AVOs, last until the next time your matter appears before the magistrate in the court. A final AVO, however, can last anywhere from 6 months to 5 years. Regardless of the status of your AVO, whether it be provisional, interim, or a final AVO, it is important to remember that all AVOs are enforceable.
AVOs contain different types of orders depending on the situation, but all AVOs prevent the defendant from being violent or aggressive to the person or people needing protection. This includes stalking, intimidation, and harassment. Two things to keep in mind: neither you nor the other party has the power to change the AVO without going to court to get new orders. It's very important that you don't ignore the orders set out in the AVO. Your first time in court is not your chance to tell your story. All the court wants to know is whether the applicant wishes to go ahead with the AVO and whether the defendant wants to consent to or defend the AVO. There's some basic language you'll need to be familiar with when you are in court. The applicant is the person who is applying for the AVO. The person or people who are protected by the AVO are known as the PINOP, which stands for Person or People in Need of Protection. The defendant is the person who must obey the AVO if it is made.
AVOs can be applied for by the police on behalf of a person in need of protection, or an individual can apply privately at the court registry. An applicant must prove to the court that the PINOP fears the defendant will be violent towards them, stalk or intimidate them, and that the fear is reasonable in the circumstances. The applicant must bring evidence to court to support their claim. AVOs are granted on the balance of probabilities, so unlike in criminal cases, the applicant only needs to convince the court that the AVO is probably necessary, not definitely necessary. If you are a woman who is a protected person, you can use the safe room while you're waiting to appear before the magistrate. The Central Coast Domestic Violence Court Advocacy Service, or DVCAS, can help you talk to the police or connect with other support services, such as health, housing, financial counselling, emotional support, and family support services.
If you're a defendant, you have three options: consent without admissions, or defend the AVO, or in some cases, to enter into undertakings. You can agree to the conditions set out in the AVO without admitting to any of what the applicant says you have done. If you consent, an AVO will be made straight away. This will be a binding court order. Any breach of the AVO may result in you being charged with contravene AVO, which is a criminal offence. There are criminal consequences, including up to 2 years imprisonment if you are found to have broken the orders. If you choose to defend the AVO, the magistrate will set down a date for a hearing. It is at this hearing that you will be able to tell the court your side of the story. The court will make a timetable that states when you and the other party need to give your statements and any other evidence to the court in preparation for the hearing. This is called filing your statement. If you don't comply with the magistrate's timetable, a final AVO may be made or dismissed without your input, and you may end up having to pay court costs for both yourself and the applicant. Undertakings are a promise to the court not to do certain things. These are based on the orders sought in the AVO. The other party must agree to the undertakings. However, if the police have taken out an ADVO on a person's behalf, they are unlikely to accept undertakings. If the applicant agrees to the undertakings, this will mean settlement of the matter and no AVO will be made.
In order to defend the AVO, you must show the court that the applicant is not in fear of violence, stalking or intimidation, or that that fear is not reasonable in the circumstances. You will need to prepare a witness statement on a specific form and file it in the court registry. You should also attach and bring evidence to court to support your case. The evidence can include texts, emails or Facebook messages. You must file your statements and any witness statements to the court by the date specified by the court, or you may have to pay court costs. Both you and your witnesses must be willing to attend and give oral evidence in court.
Either an applicant, a protected person or a defendant can ask the court to make an order to recover any property that is in the possession of the other party. This order is called a property recovery order. This order allows you to recover personal property only, but you must prepare a list of items for the court first. The best time to ask the court for a property recovery order is the first time you appear in front of the magistrate for the AVO. If you need to recover property, it's best to get advice from a lawyer before the final AVO is made.
An AVO is not a crime and does not appear on your criminal record, but it is a criminal offence not to follow the conditions set out in your AVO. The penalties can include both fines and going to prison.
If an applicant makes false allegations in order to have an APVO made against someone, they may be liable for up to 12 months imprisonment and/or a fine of $1,100.
If you need more advice about your AVO, you can contact a private solicitor, our office or legal aid.
Be aware that if there are any criminal charges related to the AVO, you might prefer to speak to a legal aid lawyer. Depending on your situation, an AVO might also mean you need help with tenancy or renting law, family and community services or care and protection law, or money issues.
Please speak to us or another lawyer if you think these issues might be relevant to you. If you or your family are Aboriginal, you can ask to speak to our Aboriginal Access Worker. They can support you at appointments with our lawyers and at court.
This video was created by the Central Coast Community Legal Centre. Thanks for watching. The content of this video is provided for information purposes only. It does not constitute legal advice and should not be used as such. You should get legal advice from a solicitor if you have any questions about your particular case. The information contained in this video has been formulated with all due care, However, Central Coast Community Legal Centre does not accept any liability to any person for the information we provide here. The information is provided on the basis that all persons undertake responsibility for assessing the relevance and accuracy of its content.